So it is our privilege that at least JSA has come on the platform of FICCI, and we welcome you on behalf of Madhya Pradesh. We can start our session. And there are topics based on MSME, rehabilitation, relaxation and relief because of the COVID-19. There are burning problems for MSME, and we welcome you as in law associates, the renowned law associates of India, and probably and are hopeful that for MSME you will have a soft corner and you will guide us properly. Our 3-4 topics are major topics which probably will reflect our startup. Number 1 is the cash flow. Number 2 will be employees, beneficiaries who have already left, and we will have to generate new one, and then to start it and how to pay their salaries. And then later on the finance will also come, because since last 45 or more than 45 days we are locked down. So the process of LCs and bill limits, which have only 45 or 60 days of recycle, they are already blocked. They have not received we have not received the payment. So those limits will not be able, we will not be able to utilize those finance also. So that should be barred, or that should be taken in consideration that they have been received, and the limit should be cleared for further receivables. These are few major problems which probably we will be facing right from startup. So we want that your good team will solve certain or guide us on these points, on these major points, and let other points where we will discuss when the question hours comes. But these are the major topics or focus points which probably the MSME need right now when they start their working. That is all, and I welcome again all of you. And I think I'll request Ms. Meenu Dwivedi to start off with her presentation, and we will follow accordingly. Thank you very much.
So before Meenu sort of starts with the presentation, which is a very, we have put together a presentation for everyone. I am Shivpriya Nanda. I chair the corporate practice of JSA, and I have got with me today, this afternoon, 3 of my esteemed colleagues covering 3 different topics. So first of all, let me wish everyone a very, very good afternoon. And I hope that you and your families are well and safe and healthy. We are all in the midst of an unprecedented crisis, with the only comparative checkpoint being the Spanish flu of 1918, which was over 100 years back. The human tragedy of COVID-19 is galloping day by day. That it does not seem to be, coming under any kind of control globally. Though India, I have to say, is doing better than a lot of other countries. But no country and no industry has remained untouched. And most of us have been left to crystal ball gaze, in the sense that we are all somewhere guessing how things will pan out. And I can tell you that I've attended any number of seminars, and I'm sure several of you have, on macroeconomics, microeconomics, and all the other various issues. And the sense that one gets is that people are really grappling with this issue. Globally, the numbers have crossed 3 million, and in terms of people infected or affected, and there have been over 2 lakh deaths. And this issue is being, discussed in different areas, in different boards. And I'm sure, all of you have also been thinking about all of this. We are living in very uncertain times. Government regulators, advisors, businesses are all grappling with the question, what should they be doing? The Organization for Economic Cooperation and Development has cancelled its forward-looking report in March. It cancelled it. So this should tell us that the answers to the problem are still being, searched. Nobody really has the answer. But our intent today is to try and help you and guide you all to some of the questions that you all have. So As I, in my introduction, as I said, I've got 3 of my colleagues covering different areas. So we will be starting with Meenu Dwivedi, who will be covering the employment issues. And Meenu is an employment law. She's a very well-respected employment law. She's practiced in this area for the past several years, close to 15 years. This will be followed by Amar Gupta, who's a very senior litigation expert in our firm. And he will be covering issues of force majeure and similar, because his forte is dispute. So he will be covering those issues. That will be followed by Kumar Mangalam Vijay, who's our tax expert. He leads our direct tax practice. He's been practicing for over 22 years. Apart from being a lawyer, he's also a qualified chartered accountant. And to tell you a little bit about JSA, JSA is a firm of over 325 lawyers. It has been in business for close to 30 years now. And it covers, all the areas of law that could concern a business. We don't really, advise individuals, except advising high net worth individuals on, estate planning and that kind of stuff. So that's what we do. But over to Meenu to help you understand some of the employment issues. And I'm sure all of you have been following up the newspapers and are aware of the various judgments that have been coming up. But Meenu will sort of break it down for you so that you can ask the questions and you can understand, get better clarity. So Meenu, why don't you go ahead and start with your presentation?
Thank you, Shivpriya. So as we all know, India is under a temporary nationwide lockdown until the 3rd of May. There will be some relaxations for certain kinds of businesses from the 4th of May. The existing labor laws are normal situations. They do not address the exigencies arising out of the COVID-19 outbreak. As the labor laws are not adequate to deal with the current crisis, the central government and state governments have invoked the Disaster Management Act and the Epidemic Diseases Act. Under these two laws, several orders, advisories, guidelines, and circulars have been issued by the state governments as well as the center. Amongst all these orders and advisories and guidelines, insofar as employment issues are concerned, the most relevant is the Ministry of Labor's advisory of 20th March and the MHA order of 29th March. In terms of this advisory and the MHA order, it appears that the government's intention is to maintain status quo insofar as employment status of employees is concerned or their income is concerned. Once the lockdown has been lifted, it should be possible for employers to renegotiate the employment terms with their employees, both who are workmen and also those who are not workmen. This also brings an important point for consideration. In the normal circumstances, an advisory is not legally binding in nature. However, as we have seen, there is an order of the Supreme Court which was passed on 31st of March this year, that is during the lockdown. This order holds that an advisory, which is in the nature of an order by a public authority, will attract the penal provisions under the IPC. Also, in this order, what comes out is that state governments, citizens, and public authorities are expected to comply with all the advisories, directives, and orders that are issued by the center in letter and spirit in the interest of public safety. So this slide talks about the several orders, advisories, letters that have been issued by the center. We will not go through all of these individually. The next two slides again talk about the various orders that have been issued at the state level. We will not be going through each one of them individually, as we will be sharing this presentation with you after the webinar. But as I mentioned, the main points that are coming out from all of these advisories, all of these orders, guidelines, is that employees need to be kept on the payroll, which means you cannot terminate them during the lockdown. You need to pay them their wages during the lockdown period. There are those categories of employees who are not working because their establishments have been closed. You still need to pay them their salaries during the lockdown and treat them as if they are on duty. So coming to the main concern that most employers have, what are their payment obligations during the lockdown period? So in terms of the Ministry of Home Affairs order of 29th March, during lockdown, wages need to be paid to workers. This essentially means three things: that you cannot reduce the wages. You cannot tell the employees that now instead of 5 days, I need you to work only 2 days. And because I need you to work only 2 days, so I will give you less salary. Your salary is reduced from today onward for next 2 to 3 months. That is something which is not permissible. Another thing which cannot be done is that you cannot tell employees that I will pay you, but not now. I will pay you after 2 months or after 1 month, or instead of salary, I will give you stock options. Another thing which cannot be done is you cannot make deductions from wages. When I say you cannot make deductions from wages, what I primarily mean that normally what wages you would be paying your employees on a month-to-month basis, you will pay the same wages. However, we will talk about it. There are some components in the wages which you may decide to not give the employees right now, and that should be okay in the circumstances. So the MHA order talks about payment of full wages to workers on the respective due date without any kind of deduction. However, it does not clarify what is meant by workers. Do we mean only the workmen employees? Do we mean those employees also who are not workmen and not managerial? And is the intention of the government that even the managerial employees who are exempt from the State Shops and Establishment Act, they should also be paid full wages during the lockdown period? Another important question that arises is what is meant by wages. There is no explanation as to what should be paid. There are several labor laws. All of them have a definition of wages. But in the context of the MHA order, what should employers consider as wages for compliance purposes? The Payment of Wages Act is the primary statute which talks about payment of wages. So one can rely on the definition of wages to comply with the payment obligation that they have during the lockdown period. So as we will look at the definition, under the Payment of Wages Act, wages mean all remuneration, whether it is being paid as salary, allowance, or otherwise. If the employee was to fulfill his employment terms, there are certain amounts which are included. So if a certain amount is being paid pursuant to an award or a court order or because of a settlement between the parties, that amount needs to be included. Amount that is payable in respect of overtime work or leaves, that is also to be included in wages. If any additional remuneration is payable to employees, whether it is called bonus or another terminology has been used to describe it, that will also be payable. Similarly, certain things are excluded. So if there is a bonus which is payable, but it is not part of the employment terms, then an employer can choose to not pay it. Similarly, the contributions that are made towards social security, that is not part of wages. Traveling allowance or a traveling concession, and likewise food allowance, is something that the employer can choose to not pay in the current circumstances. And gratuity, of course, is payable when an employee leaves service. So it will not be considered as a part of wages. Many people have argued that in the current situation, if there is no work, why should they pay employees? They want to adopt the principle of no work, no pay. But this principle applies when an employee willfully absents himself from work. In the current situation, entities have been asked to close down their establishments, and employees and individuals have been directed to stay at home. It is not a case that they have decided on their own to not report for work. So the principle of no work, no pay will not apply in the current circumstances. Also, because several lockdown orders require that employers need to treat their employees who are not able to work as being on duty during the lockdown period. As such, you cannot apply the principle of no work, no pay in the current circumstances. Once the lockdown has been lifted, unless some new requirements come in, it should be possible for employers to negotiate new terms of employment, both with their workmen employees as well as the non-workmen employees. In case of workmen, they can either follow the route of Section 9A of the Industrial Disputes Act and issue a notice of change, or they can enter into a settlement with the workmen through the trade union and file that settlement with the labor authorities under joint application. Insofar as payment of contractual bonus is concerned, employers can decide not to pay this bonus during this period. However, this decision will largely depend upon what are the terms of the employment agreements negotiated with the employees. What is the bonus policy of the organization, and whether the company has the authority to unilaterally amend such policies. Of course, insofar as the statutory bonus, which is payable under the Payment of Bonus Act is concerned, that bonus continues to be payable as per the statutory provisions. Insofar as apprentices are concerned, even they have to be paid stipend during the lockdown period. Leaves. We will talk about the grant of sick leave, casual leave, or earned leave and unpaid leave to employees during the lockdown period. As far as earned leaves are concerned, this is a statutory entitlement of employees. So it needs to be exercised at the employee's option. An employer cannot tell its employees that, you please utilize the lockdown period, please take your earned leave now. At best, an employer can encourage employees to utilize their leaves during this period. They cannot compel employees to utilize their earned leave during the lockdown period. Similarly, because various lockdown orders require employers to treat the lockdown period as employees being on duty, you cannot really tell the employees to go on unpaid leave during this period. In certain states, such as UP and Karnataka, there is a requirement to give 28 days of additional paid leave if an employee is affected by COVID. While there is no such obligation in the other states, Given the communicable nature of the disease and employer's duty to provide a safe environment which is free from harm, employers may consider giving sick leave to employees who have contracted COVID-19. Moving on, layoffs. Layoff is essentially when an employer is not able to provide work to employees, so the employer keeps the employees on its payrolls at a reduced pay. Now, certain factories need to obtain the permission of the labor authorities to lay off even a single workman. However, natural calamity is an exception to this rule. It's interesting to note that the Ministry of Finance has held in its official memorandum that COVID-19 is a natural calamity under the force majeure clauses of Government of India's procurement manual for goods. It is possible that going forward, the COVID-19 induced business disruption is considered as a natural calamity. If that happens, once the lockdown is lifted, those factories which previously required permission of the labor authorities to lay off their workmen will have more flexibility to lay off their workmen because they will not need the permission of the labor authorities. Moving on, another interesting question that most employers have is that they want to downsize. Since the MHA order requires employers to pay full salary to their employees on the respective due dates without any kind of deduction, indirectly, this order presupposes that employees will be continued in service. As such, employers cannot terminate their employees during the lockdown. There is a restriction in the MHA order. Once the lockdown is lifted, surely they can terminate their employees after that. Insofar as employment offers that have already been made to new joinees and accepted by the new joinees, employers can withdraw such offers. But if they were to withdraw such offers, it is possible that they may expose themselves to a claim for damages for breach of contract. In such circumstances, employers should exercise caution and handle the matter sensitively. They should mutually discuss the joining date with the prospective employee, possibly defer it. If there has been some agreement for payment of some kind of joining bonus, of course, they can revise the terms, but based on mutual agreement. Insofar as manpower supply agreements are concerned, of course, during the lockdown period, even contract employees, casual employees, and other outsourced employees, they also need to be paid salaries. So those arrangements will continue as per their normal terms. If any manpower supply agreement is coming to an end during the lockdown period, there is no obligation under the MHA order that the employers have to necessarily renew the term of such arrangements. Moving on to discuss some of the relief measures that have been announced for the benefit of employers. As most of us would have heard, for certain kinds of businesses, the smaller businesses that have less than 100 employees, and say 90% of those employees are earning a monthly pay of up to 15,000, for such type of establishments, the government is going to be bearing the entire social security burden. So the entire 24% of the PF and pension contribution will be made by the government for a period of 3 months. Statutory timelines for various filings, challans have been extended. The timeline for making contribution under the Employee State Insurance Act has also been extended. so employers can take that benefit in order to ensure that employees are not completely dependent on the salaries that they receive from their employers. The PF scheme has been amended. So now employees can go and withdraw a certain percentage from their accumulations in the PF fund. This is something that they could not do earlier, but now they can do. Also, certain employers, in addition to salary, are making ex gratia payments to their employees to combat the effect of COVID-19 outbreak. These amounts, which are paid as ex gratia, are now permissible as a CSR one-time exception to the normal rules. Insofar as insurance benefits are concerned, if a company's medical insurance policy included hospitalization, then the insurance company will need to cover the claims reported under COVID under such policies. Also, insurance companies have been directed to provide comprehensive insurance schemes so that those companies who are resuming operations after the lockdown, they can comply with the mandate of obtaining compulsory insurance for their workers. Now, the MHA order has raised concerns. Employers are not, there are some employers who are not able to pay salaries. So there are wage cuts, there are dismissals, there are layoffs. At the same time, there are employers who have paid salaries under protest. So employees have taken some action against their employers who have initiated these pay cuts and terminations. So in certain matters, the Supreme Court has been approached, the writ jurisdiction has been invoked to direct the employers of such employees to comply with MHA order. The Labour Ministry is also collating information from the EPFO and the ESIC regarding the companies who have implemented wage cuts during the lockdown period. This information is being collected for a report that will be submitted to the Prime Minister's office. Certain call centers have also been set up to address the grievances of employees during the lockdown. Many employers have also approached the court to challenge the legality of the MHA order, because the MHA order is one-sided to an extent. It does not factor in the reality that it is going to be very difficult for employers to meet the pre-lockdown level of remuneration when the business is not really functioning. Also, the MHA does not clarify, does it apply to private employers? What is meant by wages? What is meant by workers? So there are 4 petitions before the Supreme Court. It remains to be seen whether the Supreme Court will uphold the MHA order. Will it interpret it in a manner which balances out the interest of both employers and employees? Will the Supreme Court hold that the MHA order will apply to private employers? And will the Supreme Court direct the center that it should provide some sort of subsidy to employers to enable them to pay wages to their workforce? Certain recent orders that have come about, so in the petitions that the Supreme Court is hearing, where the legality of MHA order has been contested, the Supreme Court has not set aside the MHA order. And it has granted some time to the center to demonstrate how it will comply with the MHA order. Just yesterday, there was an order by the High Court of Bombay In that matter, the question that had been raised to the court, excuse me, so legality of the MHA order had been contested in that case. The High Court held that the Supreme Court is already seized of the matter, so they will not take a call on the MHA order. However, insofar as payment of salaries to workers during the lockdown period is concerned, the court held that employers can choose to not pay conveyance allowance and food allowance components of the wages during the lockdown period. And in respect of those entities whose establishments are functional, but employees of that establishment are not reporting for work, the court held that there is no obligation to pay salaries to those workers who are supposed to come for work and the employer has excuse me, complied with all the requirements and the worker is not presenting himself for work. Thank you. With that, I hand over the session to Mr. Amar Gupta.
Good afternoon, ladies and gentlemen. Meenu has talked at length about one of the very most important stakeholder in your business, the employees. I will talk a little bit about the other 2 or 3 stakeholders in your business, namely your suppliers and your buyers, and possibly in some businesses where the business premises is rented, your landlord. So these 3 stakeholders will usually have contracts with the businessman, and the question therefore is that how do you deal with the impact of the current crisis in your contractual relationship with these 3 stakeholders? I assume in almost all cases, there will be contracts in place, and generally the commercial contracts contain a clause for force majeure event. The force majeure event refers to an event or circumstances which arise beyond the control of the parties and which is unforeseen or unforeseeable. Something which cannot be predicted. Parties, when they wrote the contract, did not imagine that the event or the circumstances will arise. COVID-19 outbreak is one such event, and this should qualify as a force majeure event under most commercial agreements. These clauses are provided in commercial contracts to allocate risk between the parties, meaning thereby that if the unforeseen event arises and there is disruption in business, what will be the consequence of such disruption? Who will bear the consequence? So in that sense, force majeure clause really is a risk allocation mechanism in the contract. Meenu, can you move to the next slide, please? So as I said, that most businesses will have contracts with their suppliers as well as their buyers and their landlords. So the most common scenario will be that there is a contract and there is a force majeure provision in that contract. The second possible scenario is that though there is a contract, but the force majeure clause is absent. Somehow either parties omitted to provide for it, or they did not consider it necessary to make a provision. The third scenario, which will be quite rare, will be when the contract has a clause, but it does not provide the events such as the present one, such as the COVID-19 outbreak. Next slide. So if the contract has a clause, then the answer is easy to find. You have to look at the clause, read it carefully, and understand whether the current event, the current crisis is covered by that clause, by the language and wording of the clause, and what will be the consequence that the clause provides for it. If there is if the clause covers the event, the present event, and the consequences provided, then the parties will have to abide by the provision made in the contract. While looking at the provision in the contract, two principles you need to bear in mind. That first, the rule of strict interpretation. The court generally do not interpret force majeure provision liberally. That is to mean that the words are given narrow meaning, the language is given narrow meaning. So in order to seek excuse from performance of an obligation under a force majeure provision, then the party seeking to be so excused must show from the clause, the plain wording of the clause itself, that the event is covered by the clause and the consequence provided in the clause excuses him or her from the performance. The other requirement principle that you need to keep in mind is that the courts require that the party seeking to rely on a force majeure provision must notify the other party. So, for example, in your contract with your buyer, there is an obligation to deliver the supply in a specified time, and you are not able to do that, to effect the supply within that time because of the current circumstances. The agreement has a force majeure provision, and that force majeure provision does include a crisis, COVID-19 crisis like event, and it provides that in such a case, the performance will be postponed or delayed or suspended, meaning thereby that the supply that you are required to make will be suspended, can be suspended for the period of disruption on account of the crisis. Similarly, in your contract with your supplier, there could be a like situation, but here it is quite more likely that the supplier will be seeking delay, the postponement of performance than the business will do. The third scenario can be that you have a vendor who has a similar contract, and that contract too has a provision. The consequence, again, to conclude the point, the guiding principle will be the clause in the contract, and the answer for the consequence for events such as this will have to be found in the clause. Next slide, Meenu. Now, if there is a contract which does not have the force majeure clause, the clause is totally absent. In that case, it can be argued that under the Contract Act, under Section 56, the situation such as this is covered, and under that section, the businessman can seek relief from performance. Under Section 66, there are 2 or 3 requirements that must be fulfilled before that section can be invoked and the relief from performance can be obtained. The first requirement is that the event should be such as that it has changed the circumstances totally and radically different from the circumstances which parties had taken into contemplation while entering into the contract. The second requirement is that the impossibility of performance is such that it is not only physically impossible, but it is also commercially impracticable to perform. So impossibility the word impossibility referred in the section means physical impossibility as well as the commercial non-practicality of the performance. And the third requirement that must be fulfilled is that the event is such that it is beyond the contemplation of the parties. So in the current circumstances, one could say that events such as this was beyond the contemplation of the parties. Party did not foresee that events such as COVID-19 would occur. None of us imagined, in fact, 2 months back, that something like this will happen and all of us will be locked into our homes. So far as the impossibility of performance is concerned, it will depend on the nature of the obligation. If the obligation is such that which is not only physically impossible, but commercially impracticable to do that, then in that requirement will be fulfilled. The third test regarding the change in circumstances being radically different, that test will also be fulfilled in this case because of the economic impact the current crisis has had and the business disruption that the crisis has caused. It is also possible to argue under Section 56 that the performance under the contract is temporarily suspended, meaning thereby that the contract is not totally frustrated and therefore discharged and parties are freed from the contractual obligation. It is possible to argue, depending on the nature of the contract, that to argue that the contract has been suspended temporarily, and once the disruption is over, once the situation normalizes, the parties will be required to implement the contract. Next slide.
अमर,
Yeah.
आप ये कह रहे हैं कि अगर मतलब डिले हो गया किसी को परफॉर्मेंस में, तो देयर इज अ वे आउट, मतलब कुछ
Yes.
थोड़ा
Yeah. If the contract has a provision which provides for suspension of performance, तब तो it's easily answered question, तो बिल्कुल problem solve हो गया.
तो सस्पेंशन, अगर कॉन्ट्रैक्ट बोल रहा है कि अगर कुछ इस तरह का इवेंट हो गया जैसे हम एक्सपीरियंस कर रहे हैं, तो आप कॉन्ट्रैक्ट को परफॉर्मेंस जो है उसको कुछ दिनों के लिए डिले कर सकते हैं.
डिले कर सकते हैं, ये होता है कमर्शियल कॉन्ट्रैक्ट में, ऐसी प्रोविजन होती है. अगर नहीं है तो ये आर्ग्यू किया जा सकता है कि अंडर सेक्शन 56 also there can be suspension of performance and the performance can be delayed, and for that no penalty will be imposed because of the circumstances which were beyond the control of the parties and which were totally unanticipated. Parties ने कभी सोचा भी नहीं था. In fact, हम लोगों ने शिप्रिया 2 महीने पहले नहीं सोचा था कि something like this will happen.
ठीक है.
Next clause. Next slide. Now, there can be a situation where the clause is present in the force majeure provision is contained in the contract. The contract has a force majeure clause, but it does not specifically refer to the COVID-19 situation. Then in that case, it is open to argue that the COVID-19 situation will fall within the definition of force majeure due to its overwhelming and hugely disruptive consequence that it has on business. But there is no direct precedent to support that position, and therefore the argument is available, and the correctness of that argument will have to be determined by a court. Now, next slide, please. The third kind of third stakeholder in your business possibly can be the landlord if the business premises is not owned by the businessman but it's rented. In that case, the question will be that how do you deal with this situation? So in most cases, the lease agreement would provide for a situation such as this, but it is equally likely that it may not. And in that case, if the lease does not provide for the clause, provide for the event such as this, then you cannot rely on Section 56 to seek relief from payment of rent, etc. because there are Supreme Court decisions which have held that the lease is not covered by Section 56 of the Contract Act, and it cannot be invoked in relation to the lease. But if the lease has a force majeure provision, then you can fully apply it and take the same arguments as I have mentioned in my previous in context of my previous slides, where the clause is clearly providing for a COVID-19 situation or like situation, then you can readily apply that clause and seek relief under that clause. But if the clause does not, the clause is there, but it does not, is silent on COVID-19 kind of situation, then you can still argue that it will be covered in that clause, depending on the wording and the language of the clause. That is all from my side. Next slide. Move on, Meenu.
Thank you, Amar. अब हम हमारे
Can we
कुमार मंगलम साहब आपको एड्रेस करेंगे. ये टैक्स एक्सपर्ट है हमारे फर्म के. कुमार, आप शुरू करें अपना प्रेजेंटेशन.
Thank you, ma'am. So good afternoon, ladies and gentlemen. I'll take you through what are the key issues that CBDT has or the government has sort of sorted out for because of the COVID-19 kind of situations over here. First and foremost, the relaxations have been provided to give relief to businesses owing to COVID-19 situation by way of an ordinance promulgated by the President on 31st of March 2020, and as well as subsequent orders of the CBDT. Deadlines under Income Tax Act and allied laws such as wealth tax, securities transaction tax, commodities transaction tax, equalization levy, Benami Properties Transactions Act, black money law have been extended to June 30th, 2020. So anything that was supposed to be undertaken during March 20th until June 29th is extended to June 30th. And these include issuing notices, intimations, orders, or for making submissions, or filing reports or appeals or other actions that are due from March 20th until June 29th. These also include the last date for filing income tax return for financial year 18-19, last date for linking Aadhaar and PAN, and last date for settling disputes under the Vivad Se Vishwas scheme without paying any additional interest, or you can call it a additional default tax. There is also a clarification has been provided that these deadlines can also be further extended, and the extension can vary for different sections. Taxpayers can make investments in saving instruments and take necessary actions under Section 54 to 54 GB of the Income Tax Act, essentially pertaining to the capital gains tax and all, for claiming the rollover benefit or allowances until June 30th of 2020. In respect of, as you probably some of you may know, that 31st March 2020 was the last date until which a new SEZ unit could have been set up for claiming the Section 10AA benefit, which is basically 15-year tax holiday. So for entities that have received the approvals from the SEZ authorities before 31st March 2020, they can now commence manufacturing of articles or provide services related to that particular section until June 30th of 2020. An important point here to note is that there is no extension for payment of any taxes. So any delayed payment of advance tax, TDS, TCS during this particular period can be deposited later, as in payments can be made with certain delays, but that would be subject to a reduced interest of 0.75% per month instead of higher rates applicable under the respective provisions, and no penalties and prosecutions for such delays are envisaged at this moment. Now, the other one, Meenu, if you could just change the slide. Yeah. A very important point to note is that only such deadlines that fall within March to May of 2020 for TDS, TCS and all, and which end with June 29th, have this particular relaxation of 0.75% interest payable, provided the payment is made on or before June 30th, 2020. But if it's beyond, then the regular provisions will apply, and it will also be subjected to maybe the penalties also. Nothing on those lines have been clarified. Minu, if you could please change the slide. Thank you. As you all know that PM CARES Fund has been instituted, and it is now eligible for 100% deduction while computing the taxable income. Donations made to this particular fund are also eligible if the contributions are made by employees through their employer, and then employer is allowed to make those changes in the Form 16 and make those declarations in the Form 16 and provide the exemption. A very important change that has been brought forward by CBDT is to extend the validity of withholding tax certificates, or rather lower tax withholding certificates that have been issued to different taxpayers for financial year 1920. These have been extended. The validity of these certificates has been extended to June 30th, 2020, where the certificates were issued for last year. If no new application has been made, they are allowing time to make an application, and within the reasonable possible time, anyone can make an application through an email to the jurisdictional officer, and the validity of the certificate that were issued for last year would in any case remain until June 30th, 2020. Very consciously, they've also taken care of the cases where non-resident taxpayers having permanent establishment are required to be made certain payments, and the Indian taxpayer who's making the payment doesn't really know at what rate he should withhold the tax. A general 10% tax withholding has been prescribed for that, for the time being. In respect of the senior citizens or persons not having taxable income who furnish Form 15G or 15H to the banks or other institutions, that validity also has been extended until June 30th, 2020. From the current year, as in from March 31, 2020, the tax auditors were supposed to report two additional things in the tax audit. One was whether the company or the taxpayer has undertaken any impermissible avoidance arrangement under the GAR, General Anti-Avoidance Regulations. And the other one was regarding the expenditure on the entities which are not registered with GST. So in order to overcome the burden on the auditors as well as on the assessees, this requirement has now been delayed by one year. Apart from this, what we have noted in respect of our interaction with various stakeholders in the MSME sector, we have a list of a couple of items that they can focus on in order to conserve the cash, and also to overcome the issues that they may have later on the tax side. And the first and the foremost being that one would need to assess, or rather reassess, in light of the new situation, as to how much of the profits which they had last year going to be there in the current year, and if there is a variation, which they need to estimate that and take care of in terms of advanced taxes, as well as, and for which the first installment will be on 15th of June, as well as in terms of if they need to go and get a lower tax withholding certificate from the tax office, then I think it has to be done proactively so that any of the amounts that are coming suffer only appropriate taxes and not much. Second thing which they need to consciously do is to assess whether any of their old demands or disputed taxes should actually be settled under the Vivad Se Vishwas scheme. And if they ought to be done, then it has to be proactively done. And now the extension is also available until June 30th to make that payment without that additional default tax of 10%. And that window is clearly very beneficial because it saves the litigation costs and it saves the penalties. It saves also the delayed because of the interest. Two more issues. I think the way in which the MSMEs conduct their business, that also must be carefully, rethought. The first one being that there is a particular section now, which was instituted mid last year, that allows companies to pay taxes at 25.17% when they choose not to take certain deductions or exemptions. One would need to see whether they ought to fall under the old regime or they ought to fall under the new regime, and it is important that they take a careful decision over there. Another decision is whether the entities that are organized themselves as partnerships or LLPs, they suffer anywhere between 31 to 33 or 33.6% tax. Should they be actually looking at organizing themselves as companies, because now companies suffer a slightly lower tax at 25.17%, and you can choose not to pay the additional 7-8% tax until the point of time when you really want to give a dividend out. So I think that these are the things that one would need to be careful about. Yeah. Other than that, yeah.
Kumar,
One would sure.
Have we finished your presentation? There's some left.
Yeah, I'm done with my issues, and I think yeah, please go ahead.
Okay, so now I would request Mr. Sogani. I know कि काफी सारे शायद सवाल आए हैं YouTube पे, तो Mr. Sogani उन questions को रेज करें, फिर हमारे जो पैनलिस्ट हैं जिसके एरिया में वो आंसर करेंगे. Mr. Sogani, are you there? Hello.
Hello, ma'am.
Yes.
Ma'am, can I have 5 minutes before Mr. Sogani takes up? I just wanted to emphasize the things which we have just now gone through, the Mr.
Okay,
Amar
sure,
Gupta and Mr. Menu and the financial Mr. Kumar Mangalam. I just wanted to conclude those sessions, and then we can go for the question answers and section. Will it be all right?
Please, Mr. Jain, go ahead.
Hello. Okay, thank you. You see, thank you very much, Mr. Amar Gupta, Ms. Minu, and Mr. Kumar Mangalam. We have gone through with total presentations which you had given. All of you have given. And thank you very much. But most of the things which probably have been communicated through this session are all based for the large and corporate sectors. You see, we as an MSME, we don't have any followed so many regulations. We don't have any written agreements with the employee and employer. We don't go for the contractual agreements and all that. And more or less, the suppliers are private sector peoples. So in my suggestion for all of you is this, that we should take over, that there should be an MSME cell for the COVID-19. And there are certain things which the government should take over. Number one is the labor laws. You see, if we'll add COVID-19 Act in the Act itself, that whatever COVID-19 has given, that will be covered by the ESI and EPF and PPF peoples. You see, as you said, that 24% has been given by the government of India for EPF and PPF. We have received the complaint that the department has denied those credits only on the basis that the papers or the things which they are available with them. The details of the employee and the employer are not matching. It is not possible. You see, when we were making the payment, everything was matching. When the government is likely to pay, they said that they are not matching. How can it be? And the EPF and ESI, they have got lot many funds. They are not being utilized. Why the MSME specifically, we pressurize for making those payments when they have not earned that amount? See, it is one-man army, ma'am. And for MSME, you can say that money does not grow in trees. For them, every bread and butter is meaningful. At the present situation, their cash flow is also is concerned. See, they have not received the payments. They have not raised their bills. They have not been able to receive their funds. So when they will restart it, that they will be facing lot many difficulties. So for the finance part of it, the bankers should also be said that they should all either give them some working term capitals to run up their businesses. They must come some booster plans to restart, and they must have some restart point where all these things, when the things you have mentioned, they are already in law. But the force majeure clause we don't have. Yes, if our supplies are going to government or PSU, there also from years together, this clause has been withdrawn by all the peoples. Neither the supplier wants, nor the trader have given any force majeure clause. This clause is definitely says when both parties agree to it. Government is also agreed that this is a natural disaster. When the natural disasters is there, then definitely the things which are already in existence will have to be rooted out again. We will have to reset our button. So that is our point, that the company like you who are doing with the large scale sectors will also guide certain things for MSME. And if they are not there, you will have to advocate our things. You will have to as an advocacy center for us. That is my submission in the three litigation with Menuji and with the Kumarji. You see, those things which you are given is already known to us, but we are concerned about the restart of our units because of all these hazards. We are not capable of carrying out all these liabilities with us. Thank you.
Mr. Jain, I think you made your point, and your point is well made. And that's why you have organizations like FICCI, and we would be happy to work with FICCI to, help the MSMEs find resolution as far as their lobbying with the government is concerned, helping FICCI work with, position papers, etc. So that's the way to do it. You have two ways. One is, lobby with the government. The other is dispute with the government.
Right.
Go to the courts and take it up. So those are, and it's not only typical for India. That's true for every country in the world. But some countries are more proactive than the others, and I think we are learning as we go along. But I know that we are short of time, so I will ask Mr. Sagar.
Can I just respond? Can I just respond to Mr. Jain for a moment?
Yeah.
If I may interject, this is Amar Gupta. Mr. Jain, in my discussion, I specifically dealt with the situation where the contract does not have the clause, or the contract is altogether absent. It's the same thing.
Yes.
So if the contract is absent, in my, I think, third or fourth slide, I specifically dealt with the scenario when the clause is absent, the force majeure clause is absent. And in that context, I submitted that it is possible to argue that the performance will either be excused or delayed as depending on what the circumstances are. So that aspect was covered in my presentation.
That is
wanted to point out.
that is quite considerable. I thank you for that. But my submission is that for MSME, an opportunity is like a biscuit. You see, you dipped it in the tea and take it out immediately. Then it's all right. Otherwise, it has gone. So the MSME presently facing that scenario. If it has been given or nurses properly right now, then it's all right. Otherwise, they will have to face a lot of problems in their
and
restarts.
One more point I would make as a legal practitioner.
Yeah.
That if the MSMEs do not have formal contracts, they must start doing it, because in the new world, the the way of doing business will have to change.
Yes.
The rules and regulations have come about, and therefore it will be advisable for the MSMEs to change
Yes.
their way of doing business.
Yeah.
Anyway,
I'll
Mr.
only
Gupta,
add, Mr. Jain, and I'll only add this and for the audience that JSA, of course, represents several large corporates, but also represents MSMEs and others, even some small scale
startups.
and NGOs, so we do work across the entire gamut of commerce. But I will now, Amar, have to move to Mr. Sogani because he's waiting in the wings. So let's, and we're short of time. Mr. Sogani, please come in. Mr. Sogani, can you hear us? Mr. Sogani, can you hear us?
I think his microphone is not working properly.
Okay, so then
How do you filter the questions?
do you have the questions then? Would you like to send them? Shantanu, why don't you ask them since we can't hear Mr. Sogani?
Yes, so thank you everyone. And that was a lovely discussion and a lot of informative things that we got to the presentation. So our audience has posted certain questions. So we have selected a couple of those. So I'll just ask those questions. The first one is, are the white collar employees also covered by the MHA advisory?
Yeah, so let me answer that question. They are covered, but what we didn't really touch upon in the thing, that during the lockdown period, you have to protect everyone, subject to what Meenu told you about what the small leeways that people have in terms of definition of wages and what all can be deducted. But you have the ability with the white collar employee to negotiate and renegotiate their contracts. If you do not have them, if you do not have contracts with them, as Amar said, now's the time to get into the contracts and renegotiate their salaries, etc. So there is, as far as the white collar employees are concerned, you will have much more, almost total flexibility, hopefully, once the lockdown is over. But you can start the process of renegotiating the contracts with them now. And which you also can, of course, do with the labor, with your blue collar. But this is something which is easily done.
Okay, so thanks for those inputs. We do have a few people from the academic background also, especially school. So there's a question that what is your take on the salaries of private school teachers? Any specific views are there?
Let me just, sorry, I was on mute. There's no specific views. Private school teachers are like anybody else, right? If they're not consultants, they're employees like in any other business, and they'll be governed by the same parameters that we've discussed. Meenu, would you like to add?
Yeah, my views are the same, basically.
Okay. So the other one is, does MHA order apply to contractors hired through third-party agencies?
Meenu, would you like to answer that question, please?
Yes. So I think what you're saying is basically, does it apply to the contract employees who are hired through contractors? So yes, it applies to contract employees, it applies to your casual workers, it applies to your blue-collared employees, and it also applies to your other outsourced staff. No distinction has been made.
But if it is, as we had discussed in some of the earlier seminars, if it's a contract, which is like a turnkey contract, and that contractor has some employees, sitting under him. For instance, you are into manufacturing of school bags, right? And you've given a contract to somebody else to manufacture the school bags for you, like a tolling arrangement, for instance. Then in that case, there is no relationship between that contractor's employees and you, and therefore you're not obligated to pay the salaries of those employees.
Yes, correct.
Thanks. And the last question, in fact, it has been discussed during the panel discussion also, in the presentation also. For the benefit of the audience, if you can repeat that, how to differentiate act of God, force majeure, and frustration of contract?
So I am asking Amar to answer this question. Amar, can you
Shantanu, can you repeat that question, please? I didn't
Amarji,
hear
it
you.
says how to differentiate act of God, force majeure, and frustration of contract.
See, act of God is a force majeure event and a frustration of contract is a consequence. Let me simply simplify this. Act of God is an event which causes, which qualifies, which is characterized as force majeure event. Force majeure का जो meaning होता है, उसको कहते हैं supervening event. It's a French term है. तो इसका मतलब ये होता है, this is an event which is a supervening event, which is beyond contemplation of the parties and beyond control of the parties. So act of God is generally provided as a...
Your microphone is muted.
I'm sorry. No, it's not. Can you hear me?
Yes, sir. Yes, sir. Please go ahead.
The force majeure, जो act of God है, वो generally the contract provision for force majeure will define force majeure to include an act of God. COVID-19 can be characterized as an act of God. There are no direct good decisions to support this, but it can be argued, and there is a basis to argue that frustration of contract is a consequence, which means that the parties are discharged from their respective obligation under the contract, meaning thereby that the parties are freed from the binding obligations and the counter obligations under the contract. I hope I have answered.
मैं थोड़ा सा इसको elaborate कर देती हूँ अमर.
Yes.
जैसे आप किसी का कॉन्ट्रैक्ट हो कि उसको 400 क्विंटल आटा सप्लाई करना है सिटी ऑफ भोपाल में, ठीक है. भोपाल में फ्लड्स आ जाते हैं, तो फ्लड्स जो है वो एक्ट ऑफ गॉड हुआ. बहुत बारिश हुई, फ्लड्स आ गए, एक्ट ऑफ गॉड हुआ, जिसके कारण वो आदमी आटा नहीं सप्लाई कर सका. तो उसका जो कॉन्ट्रैक्ट है वो हो गया फ्रस्ट्रेट, वो परफॉर्म नहीं कर सका क्योंकि एक एक्ट ऑफ गॉड हो गया. तो जैसे अमर ने बोला, एक्ट ऑफ गॉड इज द रीजन एंड द फ्रस्ट्रेशन ऑफ कॉन्ट्रैक्ट उसका रिजल्ट है. अमर, this is what you were trying to say. Yes.
Correct.
Thank you, sir. So Amit Sogani ji has joined us. So there were some technical glitches. So he is there with us. Sogani ji, if you can unmute yourself. So,
yeah, I have unmuted myself.
So Sogani ji is having certain questions. So Sogani ji is the president for Guna Chamber of Commerce, a very important part of FICCI in MP. And Sogani ji has got certain questions that he'll post, and after that he'll conclude the session. Sogani ji, over to you.
Thank you very much, Shantanu ji. Shantanu ji, I am very sorry. There were some issues or some issues in the connection, so I couldn't join and I couldn't ask the question. First of all, I'll ask a question to Meenu ji. As regard to the employees, if we cannot terminate the employee during the lockdown period, then if it is necessary to terminate a person during the lockdown period, then what we should do?
So Gani ji, what do you mean by necessary? You mean that there is no work, or you mean that you're not able to pay salary?
Actually, what is there? Suppose some of the any employee who do not turn up to the work, or he do not do the work fully or as per the norms of the employer, then in that case, in the lockdown period he can terminate him from the service?
Yes.
And what will happen if it is done?
Yes. So if an office or an establishment is allowed to function during the lockdown, then that organization can function with 50% of its workforce. So amongst the 50% workforce who are supposed to come to the office or the establishment and they are not coming, the employer can deduct their wages. They do not need to pay
Yeah.
wages to such employees. And after a couple of notices to such
Okay.
employees to come for duty, if they still do not come, then of course they can treat it as that the employee has abandoned his duty. It could be treated as a case of abandonment.
Oh, Meenu, can you just
Okay. But
clarify that?
as per the orders of the MHA,
Yes.
excuse me, as per the order of MHA, it is very clear that you are not in a situation to terminate the employee during the lockdown period. Do the notice period is necessary to be established in that time, or we have to give a salary to the employee for the period or notice period also? What will be the situation, legal situation?
So basically, during the lockdown period, even those category of employees who are not working because the factory is closed, you're supposed to treat them as being on duty and still pay them salary.
Yeah.
So you are talking about issuing a notice which will expire when the lockdown is lifted.
Yeah.
So as long as you pay during the lockdown period and give them full salary and do not terminate them during the lockdown, there should not be a problem. But you should have justifiable reasons, because in certain states you need to provide a reason for termination. So if there's a reasonable cause for termination, say there is the person is not performing up to the mark, all of that, and you can substantiate it, there should not be a problem.
Now, Minuji, I have another question. What will be the situation in the case of white collared employee?
The situation, yeah, the situation will be the same for white collar employees as well as for the blue collared employees, because the MHA order does not make a distinction. But white collar, with white collar employees, you can take their consents. They can themselves opt to take lesser salaries, and in that situation, you can pay them lesser salaries. So you have that leeway with the white collar employees, which you do not necessarily have for the blue collared employees. But blue collared employees can also opt. They can they can be an offer from their side that they want to keep their jobs. They understand that there are no jobs in the market, so they would prefer to get lesser salary and hold on to their jobs.
And in the case of private school teachers, do we should keep a specific view, or same view will be adopted for the private school teachers?
Yeah, so as Shivpriya mentioned, there is no real distinction. Just like employees in other areas, they are also providing a service. So you will not treat them any differently there.
Okay. Now there is a situation in which some of the employees, they are taking this MHA order as a cushion, and they are not willing. Suppose the employer calls them to work, or in the industrial unit or in MSME unit, they are not turning up, and they say you have to pay the salary. We are sitting in the home, and as per the order of MHA, you have to pay the salary. Now, what the MSME unit owner should do in this such situation? Where he should go, and from where he should take relief?
Mr. Sogani, as Meenu had just mentioned, that there is a High Court order of the Bombay High Court, which came yesterday, which provides some clarity. I'll let Meenu answer, but net she's just answered that question, that in case, for instance, all of essential services, they're supposed to operate. Suppose it's the electricity department, right? Yeah. Or the other services which are described as essential services, and somebody does not turn up despite the employer providing that person all the facility in terms of, the sanitation, mask, gloves, etc., whatever is to be provided, then the employer would be within his rights after following the process to terminate the person. But Meenu, you can elaborate on that.
Yeah, and they would not need to pay salary to such employees.
Okay, then in such case, local authorities, but we should go with them with the orders of the Bombay High Court, and say that the local authorities, because they are intervening in between. They say, no, you pay the salary. That is the situation. And the employees are not going to come. This is some of the situation in Madhya Pradesh, some of MSME units.
Yes, so the order of the Bombay High Court has come in only yesterday, and it will have persuasive value even before the courts in MP. So that, and as per the MHA order, the MSMEs are allowed to function, so the employees need to come for work. They cannot take the argument that we will not come for work and you still need to pay us.
Minu,
Okay.
Minu, can I?
Yes.
Go on. Go ahead.
Jain Saab, it's nice to hear something from you. I am waiting for that.
Go ahead first. Finish it and then I will come.
I'll come with another question. First of all, you.
No, you complete yourself. Please. Sorry for the interruption. क्या हो गया?
Actually, there was some telephone on my mobile.
अच्छा.
Now another question is with Amar Gupta Saab. Does MHA order apply to the contractors hired through third-party agencies also?
That's a question I think more appropriate for Meenu to answer.
Okay. Let Meenu ji take it.
Yeah. Could you please repeat your question, Mr. Sogani?
Does MHA order apply to the contractors hired through third-party agencies?
Yeah, so we spoke about it where there is a contract labor arrangement. In that situation, principal employer will need to pay the contractor as per the terms of the contract between principal employer and contractor. So the payment from principal employer to the contractor will be as per the terms of contract that they have agreed. And so far as the contractor is concerned, the contractor needs to pay salary.
Yeah.
And in case the contractor does not pay the salary to his people, then the principal employer will be liable because there is a contract labor arrangement. But where there is no contract labor arrangement, there is no, the employer who has engaged the contractor is not a principal employer.
Okay. But in some of the cases it is seen, the contractor is not making the payment, and the principal employer, the person who has taken a contract, the person who has taken the contract has to pay because he is the principal. Now they are telling to pay the employer. The employees are sitting on, you can say, hartal, and all that is happening. What will be the situation now?
See, under the law, even if it was a non-COVID scenario, the principal employer who has had to pay to the employees of the contractor, they have an option under law to proceed against the employer. There are provisions for that. So he can, proceed against the contractor.
Can I ask something specific?
Yes.
Yeah. Okay, time is going on. Now I'll ask a last question. How to differentiate act of God, force majeure, and frustration of the contract? How to differentiate that?
Okay, Mr. Sugani, I think we've just answered this question. वाला हो चुका because आपका line उस समय नहीं था तो same question उन्होंने raise किया तो हो गया.
Okay, thank you.
Thank you so much. Thank you, everyone.
Thank you.
So I'll ask Sogani ji to propose the vote of thanks, sir.
Thank you very much. First of all, to the FICCI for arranging such a nice, and Arun Jain Saab, respected Arun Jain Saab, to being with us and giving his time, along with all the technical hands of JSA. No doubt, JSA has answered us well, and the public and the people who has taken the registration would have taken a very good benefits out of this talk. And I should say FICCI to arrange such type of talks again and again, and to give all the situations and all the benefits to the public taking the registration. Thank you very much. Thank you very much. Thank you all.
Thank you all. Thank you all.
Thank you, everyone.
Thank you.
Thank you.